Good afternoon, everyone.
Good afternoon, Madam Chair.
It is Thursday, April 9th. You are in the Finance Committee, and we have still a pretty extensive voting list. I think we're going to start with concurrences first.
Thank you, Madam Chair. So the first bill before the committee to decide whether or not to concur in the House amendments is Senate Bill 412. This is Senator Augustine's bill related to the Community Forensic Aftercare Program. So the Senate Bill 412 generally codifies the Community Forensic Aftercare Program within the Department of Health. The House amendments conform the Senate bill to the cross-file House Bill 658 as this committee passed it out and as the Senate passed it earlier this session. So the amendments prohibit the court from requiring or authorizing a program monitor to make clinical decisions. To keep the bills aligned, a motion to concur would be appropriate.
Thank you, Senator Washington. I'd take a second and a vote.
Senate Bill 412.
Can I have a second? Senator Guile? All in favor of the concurrence on Senate Bill 412? Thank you.
Next is Senate Bill 496, which authorizes Medicaid to provide comprehensive coverage for the treatment of obesity. The House amendment authorizes, but does not require, the Department of Health to apply for a state plan amendment to effectuate the bill. This amendment would not result in a change to the fiscal note, and so a motion to concur would be appropriate.
Senator Hershey, will you make a motion to concur?
Motion to concur.
And a second is Senator Reedy. All in favor of motion to concur on Senate Bill 496?
No.
Thank you.
Next is Senate Bill 555. This is Senator Hayes' bill. It establishes the Dementia Services and Brain Health Program within the Department of Health and requires the creation of a toolkit for dementia care. The House amendments make stylistic changes only, and this was worked out ahead of time, so a motion to concur.
Thank you, Senator Washington. Senator Reedy. All in favor of Senate Bill 555? Okay. Unanimous vote.
Next is Senate Bill 579. This is Senator Jennings' bill that requires counties to offer no-cost preventative cancer screenings in accordance with certain guidelines to volunteer firefighters and retired volunteer firefighters. The House amendments alter the definition of retired volunteer firefighter, reducing the number of years of service required and adding an element related to length of service awards programs. The sponsor of the Senate bill is fine with the amendment. It was suggested by the Maryland State Firefighters Association. Motion to concur would be appropriate.
Motion to concur. Senator Washington. Who seconded it? Senator Jackson. Okay. All in favor, motion to concur on 579. Unanimous vote. Thank you.
Up next, Senate Bill 707 is a bill originally sponsored by Senator Reedy that defines danger to the life or safety of the individual or others. The House amendments strike provisions that would have required the Behavioral Health Administration to submit a specified report about the use of petitions for emergency evaluation. There is a plan to send a letter to the Department of Health to try to get at this information after session concludes. So a motion to concur would be appropriate if that is acceptable.
I move to concur.
Thank you, Senator Reedy. Do I have a second?
So we can full commit to making sure we get a letter.
Yes. Oh,
Yes, with the, no, I agree.
Yeah, not only to concur, but with the letter.
Okay.
Correct.
There we go.
Sorry. Yeah.
All in favor of Senate Bill 707 to concur with a letter? Thank you very much.
Next is Senate Bill 915, which requires an individual to be registered with the State Board of Physicians to perform limited X-ray machine operations in the state. The House amendments strike a change to the number of hours of didactic training that is required to register with the board as a limited X-ray machine operator, retaining the number in current law. This aligns the Senate bill with the House bill as it passed the Senate unanimously this session, so a motion to concur would be appropriate.
Motion. Senator Guile?
Yes.
Second?
Second.
Senator Reedy. All in favor of
Okay, the first one I have for concurrence is Senate Bill 22, which is a departmental bill from the Maryland Department of Disabilities. It requires them to oversee and administer affordable and accessible housing programs. And we had passed it earlier this session and then passed the House cross file as amended. And that had an additional amendment saying that the associated agencies that work with them can't use this to decide who they're giving grants to. And so this would conform this to the House bill. Senate Bill 22,
So your recommendation is
to concur.
Motion to concur Senate Bill 22 to the House bill. Senator Dial and Senator Lane. All in favor of concurrence in Senate Bill 22? Unanimously.
Next is Senate Bill 626, which was Senator Lamb's bill regarding birth certificates that allows an individual to change their sex designation for purposes of the issuing a new birth certificate. The bill was amended in the Senate. However, the House struck one of the Senate amendments that allowed the creation of a birth history document that could be used. But otherwise, the bill, it matches how it was passed out of this House, or the Senate.
Not concur. Not concur.
Second.
Is your recommendation to concur?
No.
No.
Not concur.
So what happens if we don't concur? There's a conference committee.
A conference committee or suggest the House recedes from their amendment.
So, everyone in favor of the not concur? Okay. Concur. Who wants to do a conference committee?
Oh,
I'll be
yes,
on
other
it.
stuff we can-
I'll help you out. Or maybe
No,
I
that's
won't.
okay.
Exactly.
Well, there has to be one minority, so.
Actually,
Oh, okay then.
okay. Wait a minute. They got picked.
Someone from the minority party on there.
Isn't that, that's what we always did, I mean,
Yes.
so
Two from the majority and one from the minority,
Yes.
one from the what?
two from them, yes.
Yeah,
two
but
from
I'm
the
just
majority.
saying in the House, I have seen where all three would be majority party.
But we're the Senate of Maryland.
Oh, I agree, but I'm just.
Just saying.
So we
Just
have
saying.
For Senator
So
Lamb.
you wanna be on a conference then,
No,
sounds
I
like,
do
that's what
not.
I'm hearing.
Who wants to be on the
Senator
conference
Hayes wants
committee with Senator Lamb?
Whoa.
Huh?
I don't think he knows what he agreed to. I don't know if he knows what he agreed to.
I'll do it again. I may not be very cooperative.
Maybe they'll be Senate.
That was the point of
Well, if
That's
we
the
appoint
point.
conferees,
Yeah,
Yeah. So you
it's either,
Don't appoint right away.
so recede first, okay.
Yeah.
Let's see what happens.
That's right. If you appoint conferees, then you're saying, let's go.
Yeah.
If you don't appoint conferees, you say, we may never get to conferees.
Okay,
Okay, next
Is
is,
that in my little, oh, sorry, my little diagram?
No.
Okay.
next is Senate Bill 642. It's the President's bill about the 46 alcoholic beverages district, and they had held the bill off the concurrence calendar because they had some additional amendments to make to the bill, which authorized the new issuance of a BD7 license, and Ridgely's Delight Association requires the board to make a template for memoranda of understanding that are entered into between alcoholic beverage licensees and local neighborhood associations. It allows a holder of a Class D to sell alcoholic beverages in certain hours and requires the board to adopt certain regulations for violations. And I would recommend concurring in the House's amendments.
I didn't say,
Move to concur.
I support my colleague.
okay, so we have a motion to concur, we have a second.
Second.
Okay, so we have Hayes and Dial, all in favor, concur on the Senate President's bill. Okay. Lisa, do you have more?
Yes, next is Senate Bill 656. This was the Crown and Care Act. It created a private right of action if someone was harmed by beauty products that contain certain prohibited chemicals in them. There was an amendment added on in the Senate that created the harmful hair restitution fund that was going to be administered by MDH. That was struck in the bill by the House. And this bill is coming, the House version of the bill is coming up later for voting and has amendments that would put it identical to the Senate bill as passed by the House. So I would recommend concurring in the House's amendments.
Motion to concur on Senate Bill 656. Senator Goff.
So under the bill, there were two pathways that someone could pursue if they were injured by the products. They could either do a private right of action and sue the company on their own, or they could file a complaint with the Office of the Attorney General because this was deemed a fair and deceptive trade practice, and then that money recovered by the Attorney General would go to the fund. And so people who are injured by the fund could make a claim to get money from the fund, or I think it was also supposed to be earmarked for some research for medical conditions that are related to these chemicals, like uterine fibroids and things like that. So there were some issues with MDH. They were concerned about their ability to administer the fund. The bill, as amended, does add an uncodified language directing MDH and OAG to do an analysis of how they could administer a fund that would benefit them. So I think this is giving them the ability to look into that and create their own structure for that. Yeah, let me see, sorry. So before December 1st, 2026. And so this is saying they need to develop a plan for the administration of the special fund to support the research and treatment, including screenings and diagnosis of fibroids, uterine cancer, hair loss, and related conditions caused by harmful hair chemicals. And it will consist of funds recovered by the Attorney General and earning interest of the fund.
So that would require legislation to.
Yeah, so if they did come back with this report, there would need to be further legislation to create that fund.
So we took out the private right of action and put that in.
The private right of action is still in there. It's just the bill as passed had both the private right of action and the pathway through the Attorney General. This took the Attorney General part. Or well, it's still an unfair deceptive trade practice. You just don't have the fund. That's the result of
So if
that.
someone really is damaged, cancer or whatever, they can still sue directly. That's what they have to design the account, right?
Yeah.
That's what we would be hearing back about, is how they would set up
Yeah.
that
Yeah.
account. But, you know, if you're injured, if you personally have what fibroids, hair loss, you can still directly sue the company. Okay? All right, so we had a motion and a second. In favor of concurrence?
Hopefully concur, and I'm not gonna vote for the bill.
Pardon me? Move to concur, well, you did give me a motion to
Well,
concur.
I'll second that.
Okay, we got that, but I'm trying to get a vote on the concurrence. So you'll concur, but you still don't want the bill, that's what you're.
Yes, yeah.
Okay, all right, thank you. That was unanimous, except for Senator Hayes got up. Okay, what's next?
Next is Senator Hayes's bill, Senate Bill 813, which expands provisions of law governing assignments of benefits to apply to dentists in addition to physicians. The amendment that the House Committee put on was a technical amendment to correct a drafting error. So I recommend that the committee concur in the House's amendments.
Senator Ellis and Senator Kramer. All in favor of the concurrence? Okay, now I'm down to 9.
Okay, and the last concurrence is for Senate Bill 866, which is Senator Washington's bill about sodium and added sugars for chain restaurants. As it was amended by the Senate, the bill struck most of the provisions of the bill and required the restaurants provide a QR code to access the nutritional information, and struck out the provisions requiring the warning icons to be placed on the menu next to the food items that exceeded the sodium or sugar limits. The House version kept those icons in, and the bill is similar to how it passed the Senate, except for the House version has those icons in them. Yes.
Yes,
I move to not concur.
thank you. Second for not to concur? All in favor of the not to concur? Okay, thank you very much. One more is for Amber.
Back up, the third bill on the list, SB 413, the chair's bill, State Board of Morticians and Funeral Directors, Board Operations and Regulation of Crematories and Reduction Facilities. Senate Bill 413 generally transfers all regulatory oversight of crematories and reduction facilities exclusively to the Board of Morticians and Funeral Directors. The House amendments to this bill are technical, clarifying, and conforming, and this committee moved the House bill earlier this week in the exact form that the Senate bill is now. A motion to concur would be appropriate.
Can I have a motion to concur?
Move to concur.
Senator Kramer, Senator Jackson, all in favor of the motion to concur? Unanimous vote. Okay, that's all the concurrences. We did all but one, okay. Lisa, you want to start with Senate Bill 60?
Could we wait on that one because the amendments are printing out?
Okay, we're going to wait on Senate Bill 60 because of amendments, so now we're going to do Prince George's 558. House Bill 558.
House Bill 558 renames the Prince George's County Wine Festival license to be the Wine Festival license and makes conforming changes. The bill authorizes the Prince George's County Board of License Commissioners to issue multiple wine festival licenses annually by repealing the previous limit of one license the board was authorized to issue each year. The bill also repeals a provision that prohibited the board from issuing a wine festival license in the 24th Legislative District. There are no amendments, no fiscal impact, and no opposition at the committee hearing.
Senator Guile, all in favor of Prince George's County local bill, House Bill 558. Okay. 10 to 0.
Bill, but whatever you want.
Senate Bill. All right, do we have the amendments on 611 yet? Okay.
We do have the amendments for 611. Yes. So this one increases the annual fees, applications fees, and license transfer fees for various alcoholic beverages license and permits in Prince George's County. The amendments, on page 9, the first amendment prohibits the board from issuing, transferring, or renewing certain licenses or permits unless the applicant or transferee meets certain ownership requirements and is approved by the board. And then the amendment on the next page, it prohibits certain license holders in a district other than the 23rd Legislative District from displaying certain advertisements or promotional materials for alcoholic beverages, tobaccos, or vaping products on the exterior window of the licensed premises.
Bill is amended. Is there a second?
So did you say exempt District 23 from?
From the prohibition on
From prohibition?
advertising.
23, okay. Is there a reason why 23? Okay, all right. Thanks.
I've never seen that before.
We do it. The bill that you just voted on, the previous version of that law excluded District 24.
Okay.
We just voted to remove 20, to add 24 and add other things. So
Okay.
it happens all.
All right, so all in favor of House Bill 611? Motion and a second. All in favor? Thank you very much. Okay, 10 to 0. And then House Bill 1553.
Okay. House Bill 1553 is the cross-file of Senate Bill 656, the harmful hair care that we just concurred on. It specifies that in addition to existing civil and criminal penalties, a person who violates the prohibition on knowingly manufacturing, selling, delivering, holding, or offering for sale in the state a cosmetic product that has any of the 24 listed ingredients is liable for civil damages resulting from actual harm.
Can I have a motion? So moved. Thank you. Can I have a second? Senator what?
Lisa, is this with amendments or?
Yeah, so this with amendments would conform to the Senate bill.
All in favor of House Bill 1533?
Or then we, Madam Chair, 272.
Oh, I'm sorry. We missed a bill yesterday. I missed a bill. It was a departmental bill, House Bill 272. Who's going to explain what it is? Lisa's going to explain that, please.
House Bill 272 alters the definition, duration, and license fee for an on-farm food service facility. The bill outlines requirements for the adoption of regulations related to on-farm food service facilities and expands the types of portable toilets that can be used in conjunction with food service related to agritourism. There are no amendments. Yep.
This was so the snowball stand can have a picnic table outside, but doesn't need a bathroom. Senator Mounts? Thank you. Senator Mounts and Senator Reedy. Favor of House Bill 272. Okay.
It's not on this list, it was from yesterday.
Yeah, it was, I missed it yesterday.
We're going to start with House Bill 191. In general, it establishes that for certain transactions, a merchant may not prohibit a person from making a cash payment to purchase an essential consumer good, require a person to use a credit card or debit card, or collect a higher price than charged or collected for an equivalent cashless transaction. You do have a reprint in front of you. Amendments are being offered by the bill sponsor, as well as the new amendment that the committee hasn't seen, that was negotiated and requested by Senator Hershey when he held the bill yesterday. At bill page 3, the first amendment adds the exclusion for the fuel purchases that requires a paid membership. In subsection C on page 3, this bill applies only between 6 a.m. and 10 p.m., not overnight. That is the new amendment from Senator Hershey. And then on page 4, the amendments after line 13 ensure the bill is not in conflict with the penny rounding bill.
Good old penny bill. Do you have a motion for House Bill 191 as amended?
I'll move favorable,
Thank you, Senator Kramer. Do I have a second? Senator Washington? Let's call the roll. Okay, Senator Ellis.
Yeah, thank you. So I just wanted to kind of verify that these amendments does not change the material effect of the bill as far as cash can still be accepted for essential goods,
Certain hours.
except
For
10
overnight. So from 10
overnight.
p.m. till 6 a.m., the bill does not apply. And the bill also does not apply to fuel purchases from a merchant that requires a paid membership. So think of like Costco.
Okay.
You have a membership to Costco, you get Costco gas. They don't accept cash, they only accept a card. So it excludes that. But otherwise, the bill retains its intent, and these amendments are supported by the sponsor.
Yeah, thank you. Is there anything in the bill that talks about that fee people put on, merchants put on credit card usage, like a 3%? Is that addressed?
This is not addressing the fees for charge cards, but it does say that they can't have a higher price than what's collected for a cashless transaction. So this is really requiring them to accept cash, doesn't affect anything to do with paying with a card or not.
Okay, great, thank you.
Okay, all right. So we have a motion and a second. All in favor of House Bill 191? Let's call the roll, Tammy, please.
House Bill 191, favorable with amendment. Vice Chair Hayes? No. Senator Kramer?
Yes.
Yes. Senator Reedy?
No.
No. Senator Ellis?
Yes.
Yes. Senator Mounts?
No.
No. Senator Washington? Yes. Senator Guile?
Yes.
Yes. Senator Lamb? Yes. Senator Hershey? No. Madam Chair?
Yes.
Yes. 6-4, bill passes.
Thank you. So the bill passed, 6. Okay. House Bill 564.
House Bill 564 was held 2 days ago. It's back on the list, but generally establishes consumer protection and disclosure requirements for certain registered, permitted, or licensed people in the death care industry that sell pet cremation services. The bill also establishes duties for people responsible for returning pet cremains to owners and adds graduated criminal penalties and civil penalties in the bill. It's a violation of the bill is also an unfair, abusive, or deceptive trade practice under the Maryland Consumer Protection Act. There is a reprint that you have. There is one amendment on the reprint that is offered by the chair at page 17. It is technical, but I do believe Senator Ellis has amendments to offer today.
Yes, and did you receive the amendment office?
No one provided me with the amendment, but
Okay. I know we sent the amendment to the amendment office.
to the amendment office,
should-
but it wasn't provided to the committee. I don't know if they,
It comes back to your office,
Okay,
right?
yeah, it gets returned to the requesting senator.
okay. Could we move this at the end? I'm going to call the office. Because the office did say it was done. The amendment office was done. The amendment was done, so.
But physically, the amendment should be in your office,
Or you,
or print.
it should be emailed to AA Fin Amendments to make sure the committee has it.
Okay, let's move on to the next bill, and we'll find that amendment, okay? So House Bill 711 and Senate Bill 504.
House Bill 711 generally modifies the Online Data Privacy Act, the Public Information Act, provisions of law governing access to law enforcement databases, and provisions of law governing the protections of personal records by government entities to enhance the protection of an individual's personal data when that data is to be used for the purposes of immigration enforcement. There is no reprint for this bill. There are no amendments being proposed.
Senator Val, did you think you had an amendment? No? Okay. Okay. So both the Senate bill and House bill are in the same posture. We can vote them together. There are no amendments. So Senator Lamb, you made a motion?
And a second.
And Senator Hayes second.
The Senate bill would be with amendments because we'll have to conform to the House, but
Okay. So we should vote
they
the
are in the
House
same
bill.
posture, moving the House bill and the Senate bill together.
Okay, so they'll be in the same posture?
Yes, ma'am.
Okay. Let's call the roll. You have a question? I'm sorry.
Yeah, I didn't know. I thought I had requested an amendment that, and you didn't make it over to the,
I guess
I have it
we'll have
here
to
in my
hold it until we'll hold it till tomorrow. You request an amendment here or through the amendment office?
through the amendment office.
Can you, yeah.
Look on my laptop. I usually deal with the hard copies. I'll have to do that Lifeline real quickly.
You can distribute that, or, yeah, and I'm happy to just.
Copy of what I believe you told me you wanted to do. I can speak to that if you want. You know, my understanding from what Senator Mounts was proposing is that on the Senate version of the bill, because it's just easier to read, page 6, you were looking to eliminate lines 11 through 13. So this is page 6 of Senate Bill 504, eliminating lines 11 through 13. That's what Senator Mounts was proposing. My belief is that is important to the bill, number one. Number two, there are already exemptions in the amended House version of this bill that state that you have to comply with state, federal, and local laws and regulations. So, I don't think this amendment is necessary nor helpful because there are already provisions in there that say that the folks that hold this data have to comply with federal, state, and local laws. If there is a judicial warrant, they also have to comply with that. Happy to have that conversation, but I don't think that amendment is helpful to this bill.
Yeah, and I think the purpose of the amendment is that the bill says you're prohibited from complying. However, the bill says you're prohibited from complying, and you're talking about a federal request, which you can't say you're prohibited. You can't deny that. So you're either going to violate state or federal law, and so this would at least make the recipient good with one of the two. So you're saying you can't comply with a federal subpoena or a federal request. Well, okay, you're good because you followed the state law. This becomes law. But next thing you know, because you're the recipient of that request, you all of a sudden become a felon.
So, and I know some of this may be a little confusing because we're looking at the Senate bill, which is unamended, but the House bill is what council is probably more familiar with. My understanding that the House bill as amended has provisions that state you have to comply with federal, state, and local law, right? And you have to comply with the judicial warrant, which is what, through various other pieces of legislation this body has passed before, we want them to come before a judge to demonstrate that they have evidence to be able to obtain this information, this data. The House bill, maybe council can help here with this, has provisions that say you have to comply with federal, state, and local law, right?
So I believe the language that you're referring to in the Senate bill is actually struck in the House bill, and they approach it differently. It makes this inapplicable, or parts of that inapplicable, if a controller or processor is presented with a valid warrant issued by a federal or state court that particularly describes the personal data to be accessed.
I guess I'm just concerned if you think you could become a target of one of these requests, these are people you're either not going to, you're going to isolate a class of people. I mean, if you're running a business and, it's I could foresee it without having that reassurance. And I don't think that undermines the intent of the bill. It doesn't prevent the bill from working. It just creates a safe harbor for whoever's receiving the request.
Well, I think we're trying to draw a distinction between a request and a judicial warrant. That if you are able to demonstrate probable cause by going to a judge and having them sign off on a judicial warrant, you always have to comply. You have to comply. In the House version, it says you have to comply. If it is required by federal law, you have to comply. Where I think there's a discrepancy here is if it's just a request. If it's an administrative request, that is where I think our intention is to have them go before a judge, demonstrate probable cause, and then have that warrant come forward, and then you have to comply. But if it's just a request on its own for immigration-related purposes, that's insufficient.
And so, just to add to what Senator Lamb is saying from the bill, there are two circumstances now that would require basically to not comply, but it's not really comply. There are subpoenas and summons that are not judicial warrants. So the judicial warrants are excluded. If you are served with a warrant, you comply. The bill applies to now as far as not providing the data is a subpoena or a summons that is derived from a federal, state, or local governmental unit within the 6 months that immediately precede the issuance of the subpoena or summons has engaged or supported in immigration enforcement, or if it's simply a request from a law enforcement agency and that agency has cooperated within the 6 months that immediately preceded in immigration enforcement. So it does not apply to warrants anymore as far as compliance. You should comply with warrants under the bill.
So, I mean, I would urge the committee to reject this proposed amendment just because I think, you know, we've made clear that in what council just described, if it is a federal law that requires this information to be turned over, it says nothing in the subtitle may be construed to restrict the controllers or processors' ability to comply with federal law or regulations. If you have a judicial warrant, you get that signed by a judge, you're good. But in other instances, you have to, just a request is not good enough.
Well, I don't have a written amendment to propose, and I actually, I'm not a supporter of the bill either, you know.
Right.
And I think it's important to have this discussion, though, because, I mean, this isn't a self-contrived amendment. It's one that comes from a group that will directly be involved in this, which obviously has legitimate concerns that they're not trying to, I don't think they're intended to undermine the bill. If the arguments, obviously I don't have an amendment to offer, but I think it's good to have this discussion because I think it'll probably come up, you know, in another, at another level. But the concern here is that, you know, creating this new, well, anyway, you've evaluated the amendment, the proposal, and I see it being one that doesn't undermine the bill particularly. But with that, you know, I don't have a specific amendment, Madam Chair. So I appreciate the opportunity to be able to discuss this, you know, before the bill gets moving.
Senator, I understand your concern, and I think, I mean, I actually was able to look at the language from the House bill, and I really do think it's addressed in the House bill. So we are passing the Senate bill to conform to the House bill. So I think it's addressed. I don't know where to go next. Senator Reed?
Yeah, did we, so first off, request, they don't have to grant. If it's an order from the federal government, they do.
A valid warrant.
Only judicial warrant?
Doesn't say judicial warrant, it says a valid warrant from a federal or state government.
So an administrative warrant could apply here. Well, how's that not a valid warrant?
Is the administrative warrant not signed by a judge?
Well, their administrative warrants are a common practice in the federal government. That this is one of the little tricky things that's happened in this whole debate is people go, well, we should have a judicial warrant. Well, there's a lot of federal agencies that don't use judicial warrants. It doesn't mean it doesn't have force of effect. Go ahead.
May I clarify the language? It says
Please.
by a federal court or state court, so that's going to be a judicial.
That would be judicial.
Yes.
Okay. So it has to be a judicial
From a
warrant.
federal court or a state court, yeah.
So if they get an administrative warrant, they can. What happens if a business gets an administrative warrant for this information from the Federal Immigrations and Customs Enforcement, or from some other? There could be other entities that use administrative warrants too. What happens if they refuse to them?
I assume there's an administrative process, but I'm going to defer to the bill sponsor, the Senate bill sponsor.
So an administrative warrant is not signed by a judge. It is basically a request, which is what we've been talking about before. And they would not be able to comply with that request if it comes from a agency that's involved with immigration enforcement.
So right now, we're telling people in Maryland they could just ignore administrative warrants, or does this bill allow them to ignore an administrative warrant?
This bill says that if you do not have a judicial warrant, you do not have to comply with that request, that they have to go back to, you can go back to the agency and say, can you get me a judicial warrant? And they just need to go before a judge and have that signed off on to be able to come back with, and then they have to comply, right? So the laws, this proposed legislation says that you have to comply with federal law or a judicial request. And if the holder of that data goes back to them and says that this is for an immigration-related agency, immigration enforcement-related agency, you do not have a judicial warrant, come back with a judicial warrant.
OSHA uses administrative warrants. So can these businesses just refuse OSHA? Can they refuse OSHA's administrative warrants within this bill?
The bill is limited to the administrative warrant from a federal, state, or local government unit that within the last 6 months has engaged in or supported immigration enforcement.
What about DEA? Does DEA ever collaborate with ICE?
I don't know personally, but
I hear we just busted a bunch of illegal immigrant drug dealers on the Eastern Shore. I think
federal
DEA
law
was involved.
enforcement works together, yes.
So, I mean, because they use administrative warrants too. So, I mean, I know what the agenda is. I get it. I don't support it, but I get it. But you're really like getting rid of 287G is one thing, but we're getting really far down the track here on causing some stuff. I don't think we've really counted the cost of what we're doing here. You really want businesses declining administrative warrants from OSHA, from DEA? I don't know if ATF. I was going to try to look up if ATF uses administrative warrants. I imagine they use judicial warrants. ATF does, but I mean,
what you're trying to prevent is just broad-scale fishing expeditions here. OSHA, I think, is not actually requesting MODPA regulated data, so that's different when it comes to OSHA. I think in the case that you were referring to in that drug bust with DEA, that was a criminal case. They were not doing immigration-related work there.
But they did operate. ICE was involved. They did coordinate with ICE and got information from ICE. We don't know exactly how much, but they did. I mean,
what we're trying to do here is just to make sure that when an agency comes in, they're not going through broad scale of just scooping up data to be able to filter through to use for immigration-related purposes, that if they're coming in with a specific targeted need, you have to demonstrate that request to a judge and have that warrant signed off upon. It's not just a fishing expedition through state data.
Well, no, I actually kind of understand. I mean, I do think, I'm not necessarily even against it. In fact, honestly, if we could say you could decline administrative warrants from OSHA, I might vote for the bill. There's a lot of troublemaking that really gets in the way of just common sense business practices. But I think that DEA, I mean, again, the EPA can use administrative warrants. I mean, yeah, the EPA uses administrative warrants. So now that I guess you would say that the bill limits it because they're not engaged.
They're not engaged in immigration-related activities.
Yeah, what jumped out at me was just the idea of DEA and OSHA, but I know OSHA obviously isn't doing well. I mean, I don't know if OSHA goes in. Is concerned that there's a company that, I guess their concern would be over workplace violations for anybody, not that there's people warehousing illegal migrants that have been exploited. It's just, I mean, I don't know how to amend it. I guess it's concerning. Yeah.
I would say this doesn't apply just if DEA or works with ICE on some sort of drug enforcement. It's only if they're supporting them in immigration enforcement. So if the DEA is providing information to ICE for immigration enforcement, it would apply, but it wouldn't apply, say, if it's in Senator Lamb's example where it's just criminal enforcement. They can have a joint operation as long as it's related to the drugs or whatever.
That's good, but again, like DEA informing ICE that they've arrested, they've found a bunch of people when they've busted a massive drug bust like they just did on the Eastern Shore. And like, hey, a bunch of these people are here illegally trafficking the largest amount of cocaine we've ever seized. And then we're like, well, that's 6 months. You can't do administrative warrants for 6 months because you told ICE we got an illegal drug dealer here. Like, I mean, does that not? Or are you telling me the bill that's not immigration, that's not going to hit the parameters of this bill.
I think in that instance where they're reporting to ICE that they have found immigrants, then yes, that's going to apply because that's DEA reporting immigration information to ICE.
So then if DEA wants to do an administrative warrant to some marijuana facility that they're hearing is trafficking in something that they're not supposed to be trafficking, I mean, I'm just trying to think, like, that has drugs there that are not marijuana. I mean, not to bring our friends in the marijuana industry into it, I'm sorry, that they'll probably be upset with me. Whatever, any business, DEA says, hey, we hear that there's this business trafficking drugs and that we want data on who you're supplying because we think some of the people you're supplying are, I don't know, and I'm not going to pretend to know exactly how DEA works and everything, but I'm just saying, we're not the judicial committee, so, I mean.
So in that example, they just need to bring that information data, present it before a judge, and have the judge sign off on a judicial warrant, which I think like over 95% of judicial warrants that are presented to a judge are signed off on. So you just need to, we just want to make sure there's not a fishing expedition going on here, that you just need to show the information, if there's targeted information that you want, to a judge and demonstrate probable cause that the judge would sign off on that, and then they have to comply.
Yeah, I mean, you're asking for an additional hurdle just because we're trying to send a political message, but
I don't think, I mean, there's probably a philosophical difference on whether it's a political message or protective measure, but, I think it's not unreasonable to ask a judge just to review this, and it's usually done very quickly, within an hour, maybe less, 95% of the time, they get signed off on, they can go about their business because it's a judicial warrant at that point.
Senator Mounts has a question.
risky. I'm just saying.
Senator Mounts?
To clarify one point, in that amendment concept that was mentioned, I mean, it says an investigation, a subpoena. I mean, a subpoena, are we saying that subpoenas are fishing expeditions?
They could be, I suppose, but a subpoena or a summons is not a judicial warrant. So that's where,
But you just can't issue a subpoena. Like, Johnny Lawyer just can't start firing out subpoenas. Oh, is that right?
Yeah.
You just don't answer them?
Lawyer can. It's in a proceeding. I don't know. I mean.
But there's a proceeding. There has to be a lead.
No, yeah, it'd have to be a proceeding. You have to be a.
Yeah, there has to be a.
I don't know how it works in immigration enforcement, having never practiced in that area of law, but an attorney, you don't need a court to sign off on a subpoena necessarily, so.
Correct, but you wouldn't send a subpoena unless you had open legal action.
That's my understanding as well.
Yeah. And so a subpoena would be part of that would come from the Justice Department, and so you're getting a letter from the Justice Department.
Not necessarily. A subpoena could be in a civil matter that has nothing to do with criminal enforcement, nothing to do with federal government or state government. Just two parties fighting against
So I
one
thought
another.
this was just for immigration, but this is for any.
This would be any subpoena that's provided that is from an entity that is working with immigration enforcement, if that's targeted at immigration enforcement. It's not a problem if there's no immigration enforcement data being sought. If that's not the reason the data is being sought, then this doesn't affect any of that.
Wouldn't it be easier if this were just all handled by the Attorney General? So the requests were filed to the Attorney General, and the Attorney General could say, this can be responded to, or this doesn't have to be responded to?
I think that's a policy question, Senator, that I'm not prepared to answer.
Fair.
Thank you.
One thing here. If I'm the business, how do I know whether this agency, I mean, we know if it's ICE, they'll know that. But if it's a different entity, how would I know that they have or have not engaged in immigration activity in the last 6 months?
I think they may actually need to ask also whether this information is being requested for immigration enforcement.
How's a business
So that
going to know they need to
You can't
ask that?
willfully disregard that piece of it.
Willfully, but what if the business doesn't hear about the work we've done here? I mean, I'm thinking about, I understand like a major data company probably will, but you might have other companies that could fall under this that wouldn't.
These are usually major data companies that are big data, scooping up volumes and volumes of information, aggregating it across different lines. They're pulling in, driver's license database. They may be pulling other purchase records. They may be pulling in other data that they're scraping from the internet and integrating it all together and being able to provide that and making sure that, and ICE is accessing this data. ICE is using this data that's held by third-party data brokers to be able to engage in immigration enforcement. That's the whole purpose of this bill.
Right, they're doing their job, but we don't want them to do that. I gotcha.
Well, we don't want them doing with the data that is obtained from the state.
I
We
understand.
can control state data.
I understand. So last thing, I think that council, if either one, but council, going back to what does engage mean? I just want to be sure I'm clear. I think you answered it somewhat, but I didn't ask the question quite that way. What is it? How do we define engage in the bill? I'm more thinking about from the business perspective, how they would know.
It is not defined in the bill. And the standard that you're referring to has engaged in or supported civil immigration enforcement. So it's engaged or supported, but neither term is defined. So their common meetings would be what's understood.
Anything new to add, because it's not anything new, I think we're going to take a vote.
Well, I thought maybe we want a little time to digest this amendment, Madam Chair.
Senator.
I do have one new thing to add, and that, I know the vote's about to come, but from this discussion and this issue, it seems to me it'd be a lot easier just to prevent the state from releasing this information.
That's what I'm wanting, yeah.
The state's releasing this information, they're selling this information, they're making money off of this. Not only are they releasing it, but they're making money off of it. The effective way to control this, which I think is the intent of this, is to, this market out there for data is, if there is data that shouldn't be out, who's letting it out? And it's actually the government that's letting it out. And instead, you have private entities that are getting wrapped up now in, a legal tension. Even, they're going to be hiring lawyers to figure out, and this is going to be a cost of doing business, for whatever reason. Maybe some are guilty, more guilty than others, but I'm just saying a cleaner way to approach this problem would be to go to the state and say, what information are you selling? Is there a control over what information the government is putting out on individuals? Whether it be immigration or, all the other information that's collected on us. I just wanted that was a new issue. I know we're about to vote, and I wanted to share that. Thank you.
Senator, thank you. I don't think passing this bill prevents us from doing what you just suggested. I had a motion and a second, and we are passing Senate Bill 504 as amended to conform to House Bill 711. So, Madam Chair, Tammy, will you please call the roll?
Vice Chair Hayes?
Yes.
Yes. Senator Kramer?
Yes.
Yes. Senator Reedy?
No, in explaining my vote, I don't think we should limit DEA's ability to use administrative warrants.
Senator Ellis?
Yes.
Yes. Senator Mounts? No. Senator Jackson? Yes. Senator Guile? Yes. Senator Lamb? Yes. Senator Hershey? No. Madam Chair? Yes.
Okay. Thank you all for the discussion. Okay, now we're going to go to House Bill 1120 with Amber, professional licensing portability.
House Bill 1120, finance is secondary on. Triple E has already voted on this bill. The bill is identical to Senate Bill 418 that this committee passed earlier this session. The bill explicitly authorizes a foreign service member or a foreign service member's spouse who relocates to the state due to an assignment or detail to the state and holds a license issued by another jurisdiction to practice under that license for the duration of the assignment or detail within Maryland if the individual provides specified documentation and satisfies other criteria. If a foreign service member is authorized to practice under the bill, the individual may practice only in discipline and scope of practice allowed by the license, and this does have the amendment that also subjects them to the oversight authority and disciplinary authority of the licensing entity.
So we're second on the bill. EEE already voted. Can I have a motion for House Bill 1120? And a second, please? Second. Senator Lamb. All in favor of House Bill 1120? No one opposed? Thank you. It's unanimous vote. I don't even know what number I'm down to now. 9-0. I have some new information on Senate Bill 951, so we're going to go on to House Bill 1087.
Is House Bill 1087. This requires each healthcare facility that performs surgical procedures to adopt and implement policies by January 1st of 2028 to require the use of a surgical smoke evacuation system during a surgical procedure that generates surgical smoke. There are no amendments. There is no fiscal impact. There was no opposition at the hearing.
I have a motion on House Bill 1087. Senator Guile, thank you. Can I have a second? Second. Senator Kramer. All in favor of House Bill 1087? Okay. 1, 2, 3, 4, 5, 6, 7, 8. Okay, 9-0. The number keeps changing. 9-0, Tammy.
Up next is House Bill 1249. So this bill generally codifies current practice, specifying that requirements established by a credentialing entity for certified recovery residences must prohibit a recovery residence from refusing services to an individual based on the individual receiving medication-assisted treatment for opioid use disorder, or from requiring an individual to stop or modify the individual receiving medication-assisted treatment for opioid use disorder before the individual may receive services from the recovery residence.
Senator Hayes had a question.
I was just asking, isn't this already illegal?
Yes. So under the Americans with Disabilities Act, generally, a recovery residence would not be allowed to discriminate against someone who is participating in medication-assisted treatment. The Department of Health also has explained that they are in the process of revising regulations that will effectively put this in COMAR, and so yeah, the bill wouldn't be necessary in those under those circumstances. You want to hold? Okay.
Motion on House Bill 1249.
What do you think, Vice Chair?
It's up to you.
I'm sorry, is it necessary then?
No, not necessary.
Is that what I'm hearing?
Well, did we get the bill passed on the registration? The senator's bill that required that we register, that all these houses be registered, did that pass?
I don't know. You're referring to Senator Attar's bill that would require all recovery residences in the state to be certified. I don't know the status of it. I need a moment to be able to.
All right, let's hold this and we'll get back to that.
Can I just
Okay.
add one thing to that?
Yes.
I think the difference here is that this may be federally illegal, but since we are giving state money to these sites, you know, I think the thought process here is that we should be making sure that individuals that are getting state money aren't discriminating. And I think that's the intent and purpose of this bill. So,
But if it's already in COMAR, Senator, I mean, that's the enforcement. Why do we need a bill?
I mean, I was just trying to draw a distinction between the
Yeah.
federal
I
kind of piece.
think
to
my
it.
question about the registration of the residences just gives us more information for the state to follow up. Let's yes, Nathan.
So the
The walking
regulations.
encyclopedia tells me it's in Comar.
So MDH is currently undergoing a substantial revision of 1063 of Comar. Those regulations are in draft form, and my understanding is that they'll be submitted to the AELR committee by the end of the month.
Okay.
So that would be the state
Okay, so not yet in process.
in process.
It's in the draft version.
I had that conversation with the department this afternoon.
Takes us to House Bill 1284, Delegate Gazone's bill, residential service agencies, private duty nursing.
House Bill 1284 requires the Department of Health to adopt regulations that authorize a residential service agency, or an RSA, to provide training to specified licensed nurses after hire. So an RSA that provides private duty nursing services may employ a licensed nurse who does not meet clinical experience requirements if the RSA provides specified training and competency evaluation. And so a training program and competency evaluation are subject to approval by the Department of Health, and the bill may not be construed to affect requirements relating to occupational licensure, scope of practice, or standards of care. There are no amendments.
Have a motion favorable. Thank you, Senator Hayes. And who seconded it? Senator Jackson? Okay, all in favor of House Bill 1284 with no amendments? Thank you. I wasn't sure if you were asking a question or? No. Thank you, Senator.
The next bill is House Bill 1434, which requires the Department of Health to develop and maintain a centralized caregiver resource webpage for caregivers in the state. The webpage must be posted in a conspicuous location on the Department of Health's website, and it goes on to explain some of the required content. MDH must coordinate with the Department of Education, Aging, the Developmental Disabilities Administration, and other relevant state and local entities. There are no amendments. There is no fiscal impact, and there was no opposition at the hearing, although the Department of Health did register that they thought that this information was already available.
Easily accessible?
I think that's where the difference of opinion lies, is in the
I didn't hear your
accessibility.
question, Senator.
No, I was asking, Council, was it easily found on the website?
Apparently, it's not like all in one central place, so
That's-
it's not easily found.
So this bill is to put
Make
it
it
all
so a
in the,
caregiver would have one place to go to
yeah,
and find
Correct.
everything.
I'll move favorably.
Thank you. Senator Jackson and Senator Hayes, all in favor of House Bill 1434.
Quick question.
Oh, Senator Kramer.
Explain me, caregivers are going to go to this resource? And what are they going to find there?
The webpage must be, let's see here, and provide plain language, easily accessible information to support all types of caregivers at different stages of caregiving.
Okay.
Also, I think it's my understanding that this bill is a collection of a host of bills together to make things more available to caregivers.
Okay.
If you've ever been a caregiver, you need all the help you can get, believe me.
Okay.
Can we take a roll call, or? No, all in favor of House Bill 1434? Senator Mouch, you okay? Thank you. Unanimous vote, Tina.
House
Okay.
Bill, thank you, ma'am. House Bill 1485 requires the Department of Health to develop a pamphlet to inform the public about the crisis response system, the state and national 988 suicide and crisis lifelines, and programs provided by the state 988 suicide and crisis lifeline. A healthcare provider or representative of the Office of the Chief Medical Examiner must provide the pamphlet to an individual on request or when reasonably appropriate in connection with a death, overdose, or behavioral health crisis response. The Department of Health must conduct a review of trauma-informed care training that is provided to healthcare providers, including training regarding family engagement and post-incident support following overdose or behavioral health crises. There are no amendments. There is no fiscal impact. There was no opposition.
I think the vice chair has something to say.
I'm looking to our good colleagues in the health department. I'm just wondering, like, where we're getting to the point where we're legislating for pamphlets. Why do we need to pass a law to do a
So the
pamphlet?
bill, if I recall, there's a parenthetical titled Tierra's Law. The the sponsor of this House bill provided testimony that the family of an individual who died from an overdose.
This isn't a administration bill? This is Chair of Health.
I don't believe it's from the administration, no. I can't speak to why it's sponsored by the chair of the Health Committee. Yeah, the Department of Health is indicating it's not a departmental bill.
That's something new.
Well, why does it say Chair of Health?
I don't know.
Come, tell us.
I don't know that the department would be aware of.
Megan would like to answer. Come up to the microphone, please, Megan. Thank you.
Thank you, Chair. Megan Lynch, Director of Government Affairs for the department. Chair Bagnall sponsored this bill in her capacity as Chair of the Health Committee.
At the request of the department?
No, sir.
Was it a drafting error or something? Can you guys do this pamphlet without a piece of legislation?
We already do this pamphlet, so we are happy to see the legislation go through.
Well, no.
We already do it, so we don't. Yes.
This amendment for, what is it?
564. House Bill 564.
House Bill 564. You should have the amendment now.
So Senator Ellis printed out his amendment and passed it out. The amendment largely affects.
Amber?
Would you mind just getting a little closer to your microphone?
Not at all. Sorry,
He's getting
Senator.
old and his hearing's failing.
Sorry, Senator. So we're going to go look at page 21. That's where the penalties are that the senator's amendment would strike from the bill. Right now, the penalty provisions say that a person who violates this part of it's under the health occupations article for licensed, someone that is licensed to engage in the operation of a crematory. A person who violates this subtitle would be guilty for a first violation, a fine not exceeding $5,000 or up to 1 year imprisonment. Second, $10,000 or 2 years, and third, $15,000 or 3 years. And what his amendment would do is strike those criminal penalties from the bill. I would just convey for the committee's information that under the health occupations article, almost every practice act under the health occupations article has criminal penalties attached to it because these are licensed individuals that were entrusting with their health care. This would be related to pet remains as opposed to human remains. So if the committee may feel differently about criminal penalties in that regard, but that is, it is not out of the ordinary to have these criminal penalties in a health occupations article.
So this whole amendment, that's all it strikes?
So this bill has been double drafted because of the Board of Morticians bill that has passed, moving the crematory oversight solely to the Board of Morticians. So since that bill is moving and is likely to pass, I'm talking about it assuming like it has passed, as in this is only going to affect health occupations article. This has also been drafted to the business regulations article should the chair's bill on morticians not take effect, in which case it would be on the criminal penalties would be under both sections because cremation would still be under both sections.
So this says if, just the idea of the bill is if someone has their pet
Cremated,
Cremated,
correct,
on word wasn't coming out. And it's not treated properly, which we've heard those horror stories about that. The first violation, they could have a fine of 5,000 or imprisonment, right? It doesn't say.
Correct, that's a penalty. It's not a strict liability by
Right.
any means. It would be subject to hearing provisions before the health occupations
Doesn't
board.
say shall, okay. Senator Ellis?
Yes, thank you, Madam Chair. So I spoke extensively yesterday with the bill sponsor, and there was an egregious violation in Baltimore County that prompted this bill. And basically, pets are not considered persons, they're considered property. And so it's kind of different from, say, health occupations that deal with humans, right, versus pets. And even though we love our puppies, right, they're considered. Yes, we do. They're considered property by the law. And the egregious violator of cremation services, they were prosecuted by the state's attorney in Baltimore County and under different penalties as far as fraud and were convicted. And so there are provisions in the law to cover violations of this Consumer Protection Act already. And I seem like adding a misdemeanor to this is pretty much adding more criminal penalties when you have civil penalties for this violation, I believe, of a consumer protection law and for violation of what's legally considered property. And so I believe and others believe that the fine, which is a graduated fine, is sufficient. And that's the reason to have this amendment remove the criminal violation misdemeanor, which can stay on someone's record for a lifetime. Okay. Thank you, Madam Chair.
Thank you. Do you have Senator Kramer?
Thank you, Madam Chair. Amber,
Yes,
just
Senator.
one question in, as I read the amendment, it says on page 9, strike in their entirety lines 10 through 17.
That's the double drafting I'm talking about. So there are two sections to the bill. Section 1 has its penalties at page 9. Section 2 is what I'm primarily looking at only because of the chair's bill that is moving, and therefore we don't need all of the regulations under the business regulation article, because cremation people will not be
okay, you're saying
supervised under that anymore. It'll only be under the health occupation.
You're saying everything is stricken here because it's duplicative and.
Of what the chair's bill would do.
So
it's
where
just-
the
yeah.
penalty provisions are revised elsewhere, it maintains the fine portion. Is that correct?
No, this would strike criminal penalties from this pet cremation subtitle that the bill is creating. There is a section 1 of the bill that creates that subtitle under the business regulation article and the health occupations article, because as the law is currently drafted, the cremation is overseen by both OCO and the Board of Morticians.
All right, but.
And then under section 2, it's only drafted to health occupations because should the chair's bill be enacted, there will not need to be anything under the business regulation article. So
Okay.
that the whole section 1 is not expected to take effect, only section 2. That's why I'm looking at that page.
Okay, but I think my question was directed more toward trying to understand somewhere in here, the penalty provisions are revised.
No,
With the amendment?
I don't.
I thought the amendment is amending the penalty
Oh,
provisions.
it's striking the criminal penalties and amending it to a civil.
That's what I'm trying to
I'm sorry, Senator.
get a handle on. Yeah.
The criminal penalties are removed. They're not being revised anywhere. It's transferring them to a civil that is revised, yes.
It just leaves in place civil fines
Under the
and
consumer protection.
eliminates the criminal penalty.
Correct, yes.
Am I correct that currently malicious destruction of property has a criminal provision that is a misdemeanor, and would it be comparable to what is currently in the bill that is being amended out?
It's my understanding that malicious destruction of property is a misdemeanor that has a 60-day incarceration penalty, but it does have incarceration and fines
Right.
that would be less than what's in here. However, the individuals performing cremation under the bill are the same individuals performing cremation on people. They're not just doing pets. They are permitted to engage in the operation of a crematory, which means they are cremating not just pets, but people. So we're entrusting them with both our family members and our pets, and there are a lot of public health things to oversee, which is why we've wanted to move this to the health occupations article, but also why some of these are being added, because pet remains, due to them being property, have not been as overseen as thoroughly in the past.
And I think for that reason, with all due respect for my good friend, the senator from Charles, I think it is relevant and important to have these criminal penalties, and I appreciate when there are concerns about criminal penalties. Typically speaking, for me, it's more so when it is a felony as opposed to a misdemeanor. We do know that felony provisions can have significant impacts on someone's ability in the future to perhaps find employment, find housing, and such. But I think in this particular instance, for many of us, our fur babies are just that. They're family members, and when they are delivered to a pet cemetery to be in what we are paying and expecting to receive in return, a dignified burial or cremation, that in this case, it is appropriate that an individual who is putting themselves out there as being in the business of providing these services, and it's not accidental if somehow a loving pet is left to be cremated and somehow turns up in an abandoned car with a pile of other individuals' loved pets. That was not an oversight or an accident. It's willful, it's intentional. And I think that in that circumstance, this is the kind of penalty I think that will help dissuade perhaps an individual from willfully doing so, as opposed to it just being the cost of business. Should they be caught, there will be a penalty to pay, a fine, that there be something that the courts have to look at that might be more appropriate. And so I think I would be comfortable with the bill in its current posture without the amendment. Just my thoughts.
Thank you, Senator.
Thank you, Madam Chair.
Does this also take it out of the human crematory?
No, only the bill language.
Okay, I got confused. The more we talk, the more confused I get.
Yes.
Thank you. All right, I think we're going to take Senator Jackson.
Yes, so just from my understanding, the same people who do cremation services for pets can also do them for humans?
I would say it's the other way around. Normally, you're going to be permitted to cremate human remains and also do pets, but correct, yes, you still, to legally do pet cremation, you must be permitted in the same form as you would be to do human cremation.
Okay. You know, I think I share in the sentiment of the senator from Montgomery County that there should be some criminal, you know, rules applied to this. Pets are loved ones. They are part of families as well. So you know. I'm done, ma'am.
Thank you. I just remember my puppy of 16 years that now sits in a little box on my mantle, and I would be very disappointed if it wasn't her remains in that box. But anyway, sure,
When
Senator.
you finish, yeah. Thank you. Is there similar penalties if someone mishandles the cremated remains of a human?
Yes, there are. Under all the Health Occupations Practice Acts, there are criminal misdemeanor penalties for a violation of the Practice Act, similar to for morticians and.
Okay. So we're making pets level with the human remains.
Senator, if I can comment, I think we're punishing businesses for not doing what they advertise and commit that, and they're licensed to do.
Yeah.
So
I understand.
let's
Yeah.
take,
Thank you, Madam Chair.
do you want to take, do we have a motion on the amendment? You'll withdraw it? Thank you, Senator. Can I have a motion for the bill? Who said that? Senator Washington? Thank you, Senator Washington. And Senator Lamb seconded. All in favor of House Bill 564 as it came from the House? One no, okay. 10-1, Tammy. Bill passes. All right, we're going to go back to, we don't have a lot of time, but we're going to go back to Senate Bill 60, and we have amendments now. Thank you.
Yep. Senate Bill 60 is a departmental bill that enhances enforcement provisions of the Workplace Fraud Act, prevailing wage law, and living wage law, and increases penalties for violations of those labor laws. There are two amendments for which you have a reprint. Some of these amendments incorporate amendments as the House cross-file was amended in the House, and some of them are additional amendments that were put on by the chair. The first changes on pages 2 through 4, the provisions that added making a false record or statement resulting in the incorrect payment of unemployment insurance benefits to make them part of the Maryland False Claims Act. Those provisions have been struck and conforming changes have been made throughout the bill. On page 5, the provision about joint and several liability has been amended somewhat.
Some of the amendments are what? What are the different?
Sorry, some of the amendments,
Well, Senate Bill 60.
yes, Senate Bill 60. And some of,
I have 2 reprints in my desk.
you have 2 reprints. This should be Senate Bill 60, 303, 625 -1.
409.
The second.
I think he's gonna ask. You said there's some House amendments and some House.
Yeah.
Can you clarify which are which?
Sure.
303, 65. So we can throw the other one away.
I guess so. Okay, no, you're fine. So the first one that strikes the provisions from the False Claims Act, those were offered by the chair. Those are on pages 2 through 4. Page 5 is the language about joint and several liability. The House amended to strike the language saying subject to citation and. The chair's amendments change jointly and severally liable for a violation to jointly and severally liable for restitution to any impacted employee of the subtitle when a violation of the subtitle is committed by a subcontractor. Additionally, the chair's amendment added in language requiring a subcontractor to indemnify a general contractor for damages, interest, penalties, or attorney's fees as a result of the subcontractor's violation unless indemnification is provided for in the contract. The next change is on page 8. Originally, the bill required the Attorney General and the Commissioner of Labor and Industry to meet at least monthly to share information. This changed it to share information on a monthly basis because the Attorney General's office was concerned about the burden of having a monthly meeting. The next amendments on page 9, striking Title 8 is a conforming amendment to striking the False Claims Act provision. The provisions under item 2, those were from the House, and they remove the ability of the commissioner to refer a complaint to the Attorney General if the commissioner declined to investigate or did not issue a citation due to a finding of no merit. So under the bill as amended, the commissioner can only refer to the Attorney General if an investigation is not initiated within 6 months. On page 14, there's
break it up so we don't, you really want to get to the end, we want to get to the end.
Can we get through all of them and then we'll come back? I just think, and these were amendments from Chamber and ABC, the contractors.
Thank you.
on page 14, this is from the chair's amendments, and this requires the Commissioner of Labor and Industry to develop a training course on the requirements of the workplace fraud subtitle, make the training publicly available, and require a contractor who has violated the subtitle to complete the training, and also requires the commissioner to develop a form language that contractors may use to advise subcontractors of the requirements of 3-903.1 and 3-914. Those are sections about the the presumption of an employer-employee relationship, and, sorry, the other one was about record keeping and notice requirements. The language that is struck on the bottom of page 14 going on to the top of page 15, those were from the House amendments, and those allowed a person to be debarred if they repeatedly violated certain workplace fraud provisions. So that's been struck. And then on page 19, it's the same provision with the House amendments where the monthly meeting has just been changed to sharing information on a monthly basis. And then at the bottom of the page is the same changes where the commissioner can refer to the Attorney General only if they have not initiated an investigation within 6 months after receipt. And finally, that same change is made on page 22 of the bill of changing the meeting to just sharing information monthly. That's the last of the amendments.
So if I understand the bill correctly, this holds a company responsible, which may be a subcontractor, for having people work for him that he does not have legally hired as an employee. He's hired them as a 1099.
Yes.
So he's not providing any benefits, unemployment, workman's comp, anything. And so this would hold the subcontractor, the company liable that did the hiring, not the general contractor of the project, unless it was the general that made this mistake, right? Or made this.
Yeah, well, so if the bill is amended, the general contractor would be liable for the restitution under that unless there was, but they do have to indemnify the general contractor with the bill's amended.
Indemnify, okay. Great, all right. So, Senator, well, Senator, okay, you're okay?
Yeah, thank you, Madam Chair. This is a lot of changes to this bill amendment. Could we put it off until next voting session so I can read this and to understand the changes?
So, can we finish on other questions and then?
Oh, sure,
and
sure.
we can ask for the whole?
Okay, yeah, thank you.
Thank you. Senator Mounts?
Yeah, thank you, Madam Chair. There was a lot there, and I remember bill hearing on this, and there was a discussion about compliance and government and all the things that kind of go into this, and there was a discussion about creating some language or something to help facilitate, preventing problems. I think Senator Hershey brought it up. And is that included in the amendments?
Like
Yeah, like an education or best practices type thing, so.
Yeah, so it's on page 14 of the reprint, and this was added by the chair's amendments that were requested by the
Okay.
contractors, and it's saying it requires the commissioner to develop a training course on the requirements of the workplace fraud subtitle and make it publicly available, and if a contractor does violate the subtitle, they're required to take the training.
Okay. So so the Department of Labor will be putting something like that together, uniform across the board that, you know.
I also asked that they redesign the form that they're using for subcontractors because I don't think an attorney can understand it. And I don't think your average contractor really understands, or your person being hired, so they are going to redesign that form. Any other questions? Senator Reedy?
Yeah, I noticed, so all the False Claims Act stuff is out of the bill with these amendments?
That was the intention, yes.
Yeah, okay. And then I was noticing on the, shoot, now I had it and I lost it. Just a minute. Sorry. On page 9 of the reprint. So this confused me when I was reading the bill earlier. Now we've amended it out, which is good, I think. But this bill, as originally drafted, was going to basically initiate, like, refer to the Attorney General a complaint that they had declined to investigate?
Mm-hmm.
Why in the world would we do that?
I don't know, I'm guessing that's why they took it out.
Okay, it's just odd. I don't understand. Some of the stuff I was trying to understand was reading for this. I think that's a good amendment. And then going backwards, apologies, back to page 5. So we've got, it looked like, I think the House bill, they were looking at the citation part of it, but they left violation. So we've got citation and violation both out, and now a general contractor is joint and severally liable for a restitution to any impacted employee. So we're going back to where the employee should be made, obviously, given what they're supposed to have, but we're not trying to go after somebody for a mistake and penalize the company beyond that, or?
Yeah, so that's the intention, is if the employee lost out on payments to workers' comp or unemployment or something, then yeah, they would be entitled for that, but they're not going to like give them the employer punitive damages.
So the treble damages thing is.
Yeah, that would.
Yeah, I think the request to hold is good though, because there's a lot here, but thank you very much.
Any other comments? We will be voting tomorrow in between sessions, so we'll come back to this. All right, well, you have 10 minutes of your life back. I'll see you on the floor at 4:30. Thank you.
Look at that.